Welcome back. Today we're going to discuss the most famous of the affirmative action cases, the case of University of California v. Bakke. It's a complicated case that helps set the stage for debates we're still having today about to what extent can you give racial preference, to what extent is that constitutional, and to what extent is that warranted in our society. As usual, it's a case that involves a real person. Alan Bakke was not a publicity seeker. There's one of the few photographs we have of him. He was just somebody who wanted to go to medical school. And so he becomes the test case of this issue of whether or not there should be affirmative action that gives racial preferences to blacks. Alan Bakke was somebody who was a pretty good student. He was a National Merit Scholar growing up in Coral Gables, Florida. He goes to college and joins ROTC to help pay his bills. And as part of the program to fulfill that commitment, he becomes a Marine, joins the Marine Corps for 4 years, and even spends a tour of duty in Vietnam, after which he decides he wants to go to medical school. He gets rejected at every medical school, partly because he's older. Some of them had age limits, which seems a bit unfair because the reason he had gotten older was he had done his duty in Vietnam, having been part of ROTC. But nevertheless, he still thinks he can get into school, and he applies to the University of California at Davis, which has a new medical school, one that had just started in 1968. And in that inaugural class of 1968 in the school, it was all white. That was something that was not intended. It's not something that they wanted at the University of California system. And so they set up a special admissions program to compensate for victims of unjust societal discrimination. And what it did was that it set aside 16 seats out of the 100 seats in every new class. And those seats would be given to people who had applied through a special program and were screened by a special committee and who had declared that they were the victims of discrimination. And in particular, it was there to benefit blacks. It was open to everybody in theory, but no whites ever used it. The committee that screened the applicants had a majority of people who were of color. And it was clear that these 16 seats had been set aside for African Americans in order to increase the diversity of the class. Well, when Bakke doesn't get in, he sues and he appeals to the 14th Amendment. It's somewhat ironic in a way, because the 14th Amendment had been ratified, had been created in order to protect the rights of African Americans, of former enslaved people. The 14th Amendment says that states can't discriminate against them. They can't deny to any person equal protection of the law. And coming out of the Civil War, that was done to make sure that states did not discriminate against blacks. But here's Bakke using the 14th Amendment to say, yes, but you can't discriminate against whites either. It's a race-neutral amendment. And more specifically, he talks about Title VI of the Civil Rights Act of 1964. There's Lyndon Johnson signing it, there's Martin Luther King, but there are Democrats and Republicans behind him, because back then there was a general bipartisan consensus that something had to be done on the issue of race. And there were Democrats who were against the Civil Rights Bill, and there were Republicans who were for it. And so you had sort of a mix of liberal Republicans and liberal Democrats who helped pass that Civil Rights Bill. And it says very explicitly, the Civil Rights Act of '64, is that no person shall, on the grounds of race, color, or national origin, be excluded from participation in or denied benefits of or be subjected to discrimination under any program or any activity receiving federal assistance. Well, that pretty much means every college, every university, but also all sorts of public institutions and even some corporations, because most of them had received some form of federal assistance. And so it becomes illegal to discriminate based on race. Now, once again, there was a law passed to prevent discrimination against blacks, but it says you can't discriminate on the basis of race in any way. You have to be race neutral. And Bakke uses that as part of the argument to say that he should get into the University of California. When he's interviewed, he expresses these opinions. And here's the admissions director, Dr. George Lowry, saying that Bakke had very definite opinions, which were based on his personal viewpoints. And basically, he didn't understand the whole problem. He was unsympathetic to the concept of recruiting minorities. And so besides not being eligible for one of the 16 quota seats, he gets a bad rating, the lowest possible rating from the person who interviewed him. He applied 2 years in a row, gets rejected 2 years in a row, and both times blacks who had been part of the special program of the 16-seat set-aside program got in, most of them with significantly lower scores than Bakke's. But it's complicated. There were a lot of other people who got in with lower scores than Bakke. For example, the dean had a special program for 4 or 5 people, where if you were a big donor, if you donated a building or something, and your kid couldn't quite get in, the dean would sort of push them over the line. And look, that happens at Harvard, that happens at Tulane, where people get preferences for a wide variety of things. They get preferences maybe if their parents went to the college. It's called legacy admissions, and Harvard does that a lot. Get preferences if your parents are a big donor, and you get preferences if you're African American. You could say, well, the African American one, that's on race, so you can't do that. Well, basically, if you're a legacy admit somebody whose parents and grandparents went to an institution, that's basically affirmative action for privileged white people. So it becomes complicated what you mean when you say that affirmative action has to be race neutral. It goes up through the California courts. Surprisingly, a very liberal justice at the state level writes in favor of Bakke, rules in favor of Bakke, and says no applicant may be rejected because of his race, and that Bakke got rejected because he was white. Had he been black, same scores, same everything else. Had he been black, he would have gotten in. He said they should just open, if they want to get more blacks, then they should open more medical schools. Well, dissenting opinion called that a cruel hoax. I mean, UC Davis had just been opened to try to, and it still was only admitting whites when it first began. And you can't just keep building medical schools. He called that sort of a fanciful speculation that you could just build more medical schools. President Carter, Democrat, was unsure at first which side the White House would come down on, the administration would come down on this issue. Administration is always, in important cases, supposed to argue its own side of the case or what it feels. And Carter had drafts both opposing affirmative action and supporting it. Finally, he picked a draft in which they supported affirmative action to make up for past discrimination. That was the reason they used, said that, yes, the law says you can't discriminate based on race, but if you do it to make up for past discrimination, that makes sense. The person who argued for the affirmative action for the University of California was Archibald Cox, very famous because he had just been the Watergate special prosecutor, prosecuting Richard Nixon a few years earlier, having been fired then by Richard Nixon. And he argues the case to the Supreme Court. And his basic argument, this is a quote from his brief, which is the outcome of this controversy will decide for future generations whether blacks, Chicanos, and other insular minorities are to have meaningful access to higher education and real opportunities to enter the learned profession. A lot of other briefs were submitted by various organizations. A very young lawyer, Ruth Bader Ginsburg, wrote the one for the ACLU supporting affirmative action. Blackman said, tried to compare it to athletic scholarships. Like we talked about, you get special treatment if you're a recruited athlete. Cox agreed and said it was really important to have athletic scholarships to help the sporting teams of each university. But Cox did say, since he went to Harvard, says, I don't know whether it's our aim, but we don't do it very well at Harvard, meaning the teams at Harvard were not very good in his time. A particularly interesting memo is written by the only African-American justice of the U.S. Supreme Court at the time, the great Thurgood Marshall. And we should read it carefully. It was a typewritten memo. It's not part of any decision. It was written while they were still arguing amongst themselves how to reach a decision. And he writes a memo that says, and I hope you'll go back and read it at some point, that if you view the program as admitting qualified students who, because of this nation's sorry history of racial discrimination, have academic records that prevent them from effectively competing for medical school, then this affirmative action to remove the vestiges of slavery and state-imposed segregation by root and branch. In other words, this is affirmative action to remedy these past discriminations. And he says, everybody talks about being colorblind. Well, ever since Plessy wasn't colorblind. Plessy v. Ferguson in 1896 said you could segregate based on race. And he says that, in American history, ours was a nation where by law, individuals were given special treatment based on race. But it was the whites who got that special treatment. So now he argues the affirmative action is needed to make up for that. The person in the middle is the person in the middle of the court is Lewis Powell, meaning the 4 conservative justices to his right and 4 liberal justices to his left. And he's the swing vote, just like Sandra Day O'Connor will be later taking his seat. It was really great because the court should not be totally politicized. It's useful to have people in the middle. And when he starts discussing with the other justices, and they all start debating how they're going to decide this court, it's clear that the 4 liberal justices are very much in favor of keeping affirmative action. The 4 conservative justices feel that it should be struck down because it gives racial preferences and discriminates based on race. And Powell crafts an argument that basically says we should not have quotas, but we should be able to take race into account. And he's able to cobble together an opinion that the 4 liberal justices agree with in part, and the 4 conservative justices agree with in part. And there's that middle part of his decision in which he's able to cobble together enough votes so that his becomes the ruling opinion with this sort of balance in which they strike down the University of California's quota system. And they say Bakke's got to get admitted because he was denied admission because of a racial quota system. But they do say also that affirmative action is permissible under certain circumstances, meaning you can't have quotas, but you can take race into account under certain circumstances, not the circumstance that the Carter administration had argued to remedy past discrimination. UC Davis had no real history of past discrimination. It was founded only in 1968. But they said that the reason you could take race into account was there was an educational benefit of having a diverse student body. This is something y'all can think about as you look around the dining halls when we ever get back into dining halls and say, okay, I'm in a diverse environment now. How does that benefit my educational opportunity? And how does it benefit an institution to reflect the diversity of society? How does that better prepare us to be in that society if we've been in college that has a diversity in its student body. And that's up to the educational institution or the other institution to make their own decision. Is this part of our mission to have diversity? And if so, and if it's a reasonable goal and desire to have diversity, the court ruled you could use affirmative action to get it. We can look at some of the liberal concurrences, which would take it even further. Justice Brennan says government may take race into account when it acts not to demean or insult any racial group, but to remedy disadvantages cast on minorities by past racial prejudice. As I say, that's not the ruling decision, but that's one of the concurrences where Brennan wants to take it even further. Thurgood Marshall says, I do not believe that anyone can truly look into America's past and still find that a remedy for the effects of that past is impermissible. And Harry Blackman says, in order to get beyond racism, we must first take race into account. And he said it was perverse. We dare not let the Equal Protection Clause, which was supposed to stop racial discrimination, we can't allow people to use the Equal Protection Clause to perpetuate racial superiority. Well, in the end, Bakke gets to go to the University of California because in this mixed decision, they did strike down the quota system. They said he was discriminated against based on his race because of the quota system. He's ordered admitted. He ends up becoming an anesthesiologist at the Mayo Clinic. And for a while, this becomes the way we deal with affirmative action. We take a middle ground approach in which we say, you can't have strict quotas, you cannot have strict quotas, but you can take race into account, especially for the purpose of your educational mission or the mission of your corporation or your institution, if that mission is advanced by having racial diversity. It means you can take race into account on admission. In our next lecture, we're going to see that there are many, many challenges to that in the subsequent 30 years since it was decided. But the principle has pretty much remained, although every time there's a Supreme Court decision, you have to wait and see because they could end up striking down this. So we'll go into that in our next lecture, how Bakke has been modified and changed and challenged over the years. But for the moment, let's chew on the fact that this is a complex issue and the court tried a very delicate balance then in terms of allowing racial preferences, but not allowing outright quotas.